My name is Andy Friedman. I'm an attorney with the law firm Friedman, Rosenwasser, and Goldbaum in Boca Raton, Florida. Today I'm going to talk to you about the difference between franchising your business and licensing your business. In many cases, clients come to me and want to expand their business through licensing as opposed to franchising. And they do so for a number of good reasons, primarily cost. So in order to comply with the laws that regulate franchising, a franchisor must prepare a franchise disclosure document known as an FDD, which contains 23 items of information about the franchise offering, and they must provide that FDD to the prospect at least 14 calendar days before the prospect pays the franchisor any money or signs a binding agreement with the franchisor. So the expense of starting a franchise program is much greater than a license program, and there are state laws where a franchisor has to register a franchise disclosure document with a state agency before the franchisor can start offering franchises in that state. So both from a cost and regulatory point of view, franchising is much more expensive, and licensing would be a cheaper and easier way to grow your business. However, there are very slight differences between a franchise and a license, and the name that the parties call an agreement or a business arrangement is not determinative of its legal status. So we have to look at the definition of a franchise to determine if your expansion plans, whether you call it a license or a franchise, meets the definition of a franchise under federal or state law. If it meets the definition, then you're going to have to comply with the franchise laws whether you like it or not. So let's take a look at the definition of a franchise under the federal law, which is the FTC rule on franchising. So it's pretty simple. There are only 3 elements to the definition of a franchise under the federal law, and they are as follows. Number 1, the payment of a franchise fee. Number 2, the licensing of a trademark or trade name or logo. And number 3, the franchisor or licensor provides the licensee with, quote, significant assistance, end quote, or the franchisor or licensor has the right to exert significant control over how the licensee operates its business. Now, in most cases, or almost all cases, with my clients who want to expand their business, they want to license their name along with their business format because they want to grow the brand. The second element is the payment of a fee of $615 or more between the time the franchisee signs a binding agreement and has been open for 6 months. Now that $615 fee is subject to CPI increases, but the bottom line is if you're going to receive $615 or more, you're going to meet the definition of a franchise. Now the third element is a little bit more subjective, and that is where the franchisor either provides significant assistance or exerts significant control or has the right to exert significant control over how the licensee operates its business. With regard to significant assistance, things like providing a marketing plan, providing an operations manual, providing training, all of those things can be elements of significant assistance. And in most cases, if you're going to license someone to grow your business, you're going to need to train them how to operate the business under your business format. The other part of the definition is significant control. So if you are going to exert significant control over how the licensee operates its business, or if you just have the right to exert significant control, you're going to meet the third element of the definition of a franchise. So some of the examples of significant control would be where you regulate where the franchisee locates its business, how the franchisee decorates its business, if there's any restrictions on hours of operations, if there's restrictions on customers, or if there are restrictions on geographic territory within which a franchisee may operate, all of those lead one to the conclusion that the franchisor has the right to exert significant control over the franchisee's business and meets the third element of the definition of a franchise. Therefore, while there may be little differences between the definition of a franchise and a license, there is a significant legal difference in that if you sell a franchise in violation of federal or state law, you could be liable personally for both civil and criminal penalties for violating the franchise law. So it is extremely important that you structure your business relationship, whether you call it a license or a franchise, to be in compliance with state and federal law. If you have any questions regarding this presentation, feel free to contact me at andrew@freedmanfranchiselaw.com. Thank you.